Okay, unit number 6. Review Section 7 of the Franchise Act of Alberta and Section 3 of the Arthur Wishart Act, Franchise Disclosure of Ontario, regarding the issue of good faith dealing. Does this include bargaining? Section 7 of the Franchise Act of Alberta states that every franchise agreement imposes on each party a duty of fair dealing in its performance and enforcement. Section 3 of the Arthur Wishart Act states that every franchise agreement imposes on each party a duty of fair dealing in its performance and enforcement. Bargaining is a process where parties communicate openly and focus on their negotiation on key issues. The term of the contract has not been yet agreed. The first three sentences states, every franchise agreement. By saying every franchise agreement, there is an understanding that the bargaining process has been completed. This section does not impose a duty of fair dealing on bargaining and negotiation. However, bargaining in bad faith can also lead to unfair dealing in its performance and enforcement of the agreement. I'd like to bring your attention to Hoffman versus Red Owl Stores. Bargaining in bad faith can bring substantial loss to a party. In the example the book gave us, the American case Hoffman versus Red Owl Stores, the franchisee sold his business without full disclosure. As a result, the prospective franchisor became a victim of bad faith in bargaining. I have to conclude, based on my analysis of the words in those sections, that these sections does not include bargaining. However, if we look at a deeper level, we can see that negotiation in bad faith does affect the agreement. Thus, it does impose a duty of fair dealing in its performance and performance and enforcement. All right. Question number 1. When is a contract not a contract? A contract is not a contract when the essential terms of the agreement are missing. Missing important details such as the parties involved, goods and service being supplied, consideration, and financial details. In the case Zinc Capital Corporation versus Faris, 2007, BC Supreme Court 527. There was no contract because it was missing an essential term of the agreement. The case involved the plaintiff loss of an opportunity to acquire the property Versatile Shipyard in North Vancouver, British Columbia. The plaintiff is seeking $10 million in damage. Alright, question number 2. Is a deal on the back of a napkin a contract? The deal on a back of a napkin can be a contract if all the essential terms on the contract are present and if it was signed. By signing it, it is presumed that the person signing the paper have read and understood the agreement and agreed to the terms of the contract. It does not matter if the contract was printed on fine paper or if it is sloppy on a napkin. A contract is a contract. Let's look at the basics, right? The essential of a contract are what? Let's see. Consensus ad ideum, meaning of the mind, intent to enter into a legal relation, offer and acceptance, financial details, consideration. These are what important elements of the contract, right? I could not find a relevant Canadian case that deals with a contract written on a napkin. I checked on Canada, I just couldn't find one. Maybe there is. Alright, anyways, number 3. Lots of documents are executed before the big one. Are they binding? There are many documents written before the big one. 3 written documents would be agreement to agree, letter of intent, and memorandum of understanding. Agreement to agree and is not a binding contract. It is only an agreement to agree on future terms. There will be key issues missing, and it will cause the entire contract to fail. The party must indicate that the signed document does not create a legal binding relation. Letter of intent and memo of understanding is also not a binding contract.